Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. Ever since its inception, IBC has been a great learning experience for all of us. And all the courts in the country have settled this law by means of various judicial pronouncements and judgments to pave the way for IBC 2016 to become a game changer and also to change the economic landscape of our country. So friends, I welcome you to Insolvency Insights, a snippet series curated by me to delve into such important judicial pronouncements under the Act IBC 2016 and to navigate through the proceedings of such judgments. So friends, let us today discuss one such case today. So friends, this is the case of Jaypee Kensington Boulevard Apartments Welfare Association and others versus NBCC India Ltd and others, which was decided on the 24th of March 2021 by the Honorable Supreme Court of India. So the Honorable Supreme Court of India, in its judgment dated 24th of March 2021, set aside an order of the Honorable NCLT, Principal Bench, New Delhi, which had inter alia approved the resolution plan submitted by NBCC India Ltd after carrying out certain modifications to the resolution plan. The Honorable Supreme Court remitted the process of approval of the resolution plan submitted by NBCC back to the Committee of Creditors of Jaypee Infratech Ltd, which is JIL, for further consideration and extended the period for completion of the CIRP by another 45 days, with liberty to the IRP to invite modified and fresh resolution plans from NBCC and Suraksha Realty to be submitted within 14 days from the date of the judgment. The judgment discusses various important provisions of the Insolvency and Bankruptcy Code 2016, including the jurisdiction of adjudicating authorities to modify a resolution plan and payments to dissenting financial creditors, and also sets out guiding principles to a legally compliant resolution plan. Now let us see what is the factual background of this case. In 2003, Jayprakash Associates Limited, that is JAL, was awarded the bid for development of the Taj Expressway project under a concession agreement executed between Yamuna Expressway Industrial Development Authority and JAL. Jaypee Infratech Limited, that is JIL, was set up as a special purpose vehicle by JAL for execution of the project, and consequently all rights and obligations of JAL under the concession agreement were assigned to JIL. JIL availed loans from various banks and financial institutions for executing the expressway project. Further, as JIL was granted certain land parcels by Yamuna Expressway Authority in lieu of the development of the project, JIL also raised monies from home buyers for the development of real estate projects on some of its land parcels. Now, Jaypee Infratech Limited started facing financial difficulties due to various factors. As a result, an application was filed by IDBI Bank Limited under Section 7 of the Code for the initiation of JIL's CIRP, which was admitted by Honorable NCLT on 9th of August 2017. During the CIRP of JIL, various issues with respect to rights of the home buyers and avoidable transactions arose, which were settled by the Honorable Supreme Court from time to time through separate judgments. Subsequently, the resolution plan submitted by NBCC was approved by 97.36% vote of the COC. And by an order dated 3rd of March 2020, the Honorable NCLT approved the resolution plan submitted by NBCC with certain modifications. Now, several appeals were preferred against Honorable NCLT's approval of the modified resolution plan before the NCLAT and the Supreme Court by way of special leave petitions. Now, to expedite the process, the Honorable Supreme Court transferred all pending appeals before the NCLAT to itself and clubbed all matters relating to approval of resolution plan of NBCC. And on 24th of March 2021, the Supreme Court delivered its judgment in the matter. Now, what were the issues before the Honorable Supreme Court? First was the supremacy of the COC and the limited scope of review by adjudicating authority. In line with its previous judgment in the matter of COC of SR Steel India Limited, the Honorable Supreme Court in the present case held that there is no scope for adjudicating authorities to interfere with the commercial decision of the COC. The limited judicial review available to Honorable NCLT extends to examining if the parameters under Section 30, subsection 2 and Section 31 of the Code have been met. If the adjudicating authority finds any shortcoming in the resolution plan, the AA may send the resolution plan back to COC for resubmission after satisfying the parameters delineated in the code, but it does not have the power to modify or amend the resolution plan approved by the COC. The next issue was payments to dissenting financial creditors. The resolution plan of Jaypee Infratech Ltd contemplated deferred payment to its financial creditors. The question before the Honorable Supreme Court was whether the dissenting financial creditors were required to be paid upfront, even if the resolution plan contemplated deferred payment to financial creditors. The Supreme Court observed that dissenting creditors cannot be forced to continue with their exposure to the corporate debtor. In other words, in cases where the resolution plan provides for deferred payments to creditors, dissenting financial creditors ought to be paid in cash or be permitted to enforce the security interest held by them. Payment by way of equity or security or any other mode of money by which dissenting financial creditors continue to be attached with the corporate debtor would not fulfill the requirements of the code. The next issue was modification of contracts and seeking reliefs. The terms of the resolution plan, which were effectively modifying the contractual terms of the concession agreement, were deemed unacceptable by the Honorable Supreme Court of India. The Supreme Court held that all the alterations in the essentials of the contract would require the consent of the Yamuna Expressway Authority. This would be the case even though the contract was not a statutory one. Without such consent, stipulations in the resolution plan modifying the contract would have to be disapproved. The court also noted that the terms of the concession agreement cannot be extended or altered by way of reliefs and concessions sought under the resolution plan. Further, the issue relating to the rights of the dissenting creditors belonging to a class of creditors. The Supreme Court observed that the home buyers of JIL fall in a class of financial creditors, and accordingly, any decision of that class taken by more than 50% of the voting share would bind all the home buyers and creditors in such class. In other words, a dissenting creditor in a class would not be treated as dissenting financial creditor for the purposes of claiming upfront payment to dissenting creditors. Further, the issue of extinguishment of rights of secured creditors, which are other than the financial creditors. The Honorable Supreme Court held that the rights of the secured creditors who are not financial creditors cannot be extinguished under a resolution plan by way of reliefs and concessions, and such secured creditors would have to be paid in accordance with the value and priority of security held by them, or their security interest would need to be discharged in accordance with the principles of law relating to discharge of security interest. So, friends, we conclude that the Honorable Supreme Court's judgment effectively reiterates that the commercial wisdom of the COC holds supremacy, and when a resolution plan does not conform with statutory parameters, the adjudicating authority can only remit the matter back to the COC and cannot undertake modifications to the plan. It would be essential for a resolution plan to provide upfront payment in cash to dissenting financial creditors. Further, secured creditors who are not financial creditors would have to be paid in accordance with the value and priority of security held by them, or their security interest would need to be discharged in accordance with the principles of law relating to discharge of security interest. In view of the judgment, it would not be possible for the resolution applicant or the COC to unilaterally modify contracts by way of reliefs and concessions or by way of terms of the resolution plan. Instead, the resolution plan would need to provide a mechanism for obtaining requisite approvals or consents from the state or central government authorities if they are the counterparties to such contracts. So, friends, we conclude that the Honorable Supreme Court and all the other courts in the country have been really contributing towards settling the various principles under the code IBC 2016 and have actually paved the way for the entire country to adopt and work towards the betterment of the society and the economic culture in our country. So, friends, I trust that you find this both engaging as well as enlightening. So, for further insights into such key judicial pronouncements under the Act IBC 2016, please like this video and subscribe to my YouTube channel. So, thank you, friends, for being here today with me. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.